Welcome to the Generis Show, your unique perspective on all things related to your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. In segment 1 this week, you'll get your weekly dose of the criminal injustice system and civil rights news, an analysis including an Ohio resident who went viral after being arrested at a football game due to her refusal to leave the stadium. Robert Kraft is no longer facing solicitation charges after the judge in his case rules the video evidence is inadmissible. And Brianna Taylor's case moves forward into a new phase with the release of the grand jury transcripts. In segment 2, as promised, we'll be taking a deep dive into driver's license suspensions in a post-COVID world. To make sure you don't miss an episode, subscribe on your platform of choice, Apple Podcasts, Spotify, or YouTube. And follow us on all of our social media outlets, facebook.com/Central Ohio Criminal Defense and at TLOBJ on TikTok, Instagram, and Twitter. Finally, make sure you check out TLOBJ.com for everything you need to know about your civil rights and the criminal injustice system. Erica, did you see Ohio resident Alecia Kitts criminally charged this week in an incident over the mandatory mask requirement at a Logan County football game?
I did. And I have been waiting for something like this to happen. I don't know about you, because with all of the fights going on between, hey, it's against my rights to force me to wear a mask, and no, everyone should wear a mask. I mean, there's just a lot of mixed information out there. And I was really looking forward to hearing about what your thoughts were on the situation and what really happened.
Let's be totally clear about this. In the state of Ohio, not wearing a mask is not a criminal offense. You can be given a civil penalty like a fine, and you can be asked to leave public or private property, but you cannot be criminally prosecuted or arrested for not wearing a mask. But it's important to remember that both private and public properties can put reasonable limits and requirements on people entering their space, including charging a fee like a public or a private park, a conservatory, an arboretum, prohibiting photography in places like museums, art installations, or government buildings, and requiring that you wear a mask while on their premises, such as sporting events, high school football games, or your local Kroger's. Each owner of the property has the right to ask you to leave their premises if they determine you aren't following the rules that they have set. In this case, a parent was ejected from the sporting game for arguing with the personnel at the stadium. And she was asked to leave, and when she refused to leave, she was arrested for trespassing. This is no different than a parent arguing with a referee and getting thrown out of the game. In that situation, the parent could also be arrested for trespassing if they refuse to leave after being told by the referee that they need to exit the stadium. If you refuse to leave a property that you have been asked to leave, that is an offense called criminal trespass, which is what Alicia Kitts was charged with. Now, she exacerbated that situation, as we all saw in the video, by then resisting arrest. And she's also been charged with that crime as well.
So talking about the video, I mean, we've talked about this so many times, where some crime or some situation where the cops are involved is videotaped by several different angles, several different cell phones, body cams, what have you. What do the videos show in this particular situation?
Well, I think the most interesting thing that this video shows is that Ms. Kitts had a mask on her person in her back pocket. She had the ability to comply with the rules and regulations of the stadium. She just refused to. And for that, she was ordered to leave the stadium. The video clearly shows everyone else in the stadium wearing a mask. When Ms. Kitts was asked to leave and refused, she not only refused, but she actively resisted. being removed from the property. She becomes combative. Her friend or relative joins in the fight against the officer. This really created a very dangerous situation, both for Miss Kitts, her relative, and everybody in the stadium. I could easily see this sort of circumstance being aggravated and accelerated to the point where deadly force is used. Now, fortunately for Miss Kitts, the officer involved in her situation used non-lethal force and tased her due to her violent resistance. This is clearly captured on video in this case in the stadium. She was ultimately charged with trespass and resisting. Her friend or her relative there was charged with obstruction of justice. Now, these are all misdemeanor charges, and most of them carry penalties of up to 180 days in jail.
So Brian, like most of these cases we've been talking about lately, because of the Black Lives Matter and like some of these arrests and people getting hurt are typically Black. And I understand that there's a difference in this particular case where it's actually a Black officer who is arresting a white woman. Is there any insight that you have with this being the case?
Oh, I think it's a very interesting dynamic how the tables are turned in this particular situation. Now, as everybody heard when you're watching the video, the several people in the stands are criticizing the officer. He is clearly marked with a badge. He has the word police in enormous letters across his back. And yet you can hear people in the stands saying, oh, this guy isn't a real police officer. This guy's some sort of rent-a-cop, this, that, and the other. So an absolute disregard for law enforcement authority. And is that because he's a Black man and arresting a white woman? Without interviews of these individuals, without more to go on, we certainly can't say for certain, but that is the appearance that is given, is that this Black man is given less authority, less respect, simply because he's a Black man arresting a white woman.
So will the attention to this case kind of skew how people look at the results of the litigation?
I think it absolutely will, Erica. Social media and general media attention always affect how a case is litigated and how a case is tried. Mask use has become such a political hot button issue, and this case is a lightning rod for the people to work out their frustration about our current state of affairs. We saw this in the threats that were phoned into Hawking schools the next day that ultimately required the schools to close. Now, this is a separate and distinct crime called inducing panic and can be as much as a felony of the second degree. So the people that made these threats to the school, they could be facing serious prison time if they are caught and charged. Now, Ms. Kitts made the classic assertion that because she has a medical condition, she can't wear a mask or she shouldn't have to wear one. Now, this is a very interesting intersection of premises law and disability law. But remember that the ADA, the Americans with Disability Act, only applies to very particular situations and disabilities. And exceptions to mandatory ADA compliance include a direct threat or a situation where a public agency or private business does not have to provide a reasonable modification to their face mask policy if the individual with the disability poses a direct threat to the health and safety of others. Because we are in a worldwide pandemic, property owners are allowed to require everyone to wear a mask regardless of individuals' needs for accommodation.
That's going to be interesting to see how this unfolds, because it's the first case that has made national news of this kind during the pandemic. Am I right about that?
I do believe you are. I have not seen a similar situation. Certainly there have been plenty of videos of Karens throwing fits in everything from Targets to coffee shops, and their male counterparts, the Carls, I guess, is what we could call them. But I haven't seen a video of any of those individuals being arrested. Ultimately, the store clerks have been able to escort them out, and while they have thrown a hissy fit on the way out, they have ultimately left the premises. This appears to be the first situation where a person absolutely refused and was arrested as a result of that. And we will certainly be following up on this story to see how Ms. Kitts' case turns out. A case that has now resolved itself is that of the solicitation and prostitution charges against New England Patriots owner Robert Kraft. Those charges have been dismissed by Florida prosecutors because the judge in the case ruled the video evidence of Mr. Kraft's solicitation acts inadmissible at trial.
Well, I'm from the Boston area, Brian, and I remember when this came out, and it's shocking, and the Patriots seem to always be getting in trouble with something, whether it's cheating or being accused of prostitution. It's unbelievable. But with this particular situation, can you just remind us exactly what happened? I know that he was charged with prostitution during a massage. Remind us of what happened during this situation. What were the circumstances?
Yeah, February of 2019, Juniper, Florida officials had conducted a sting operation against what they believed to be a day spa that was offering sexual favors to their patrons. Now, what made this particular sting operation, and these operations happen across the country every day, these massage parlors offer additional sexual services, and there are sting operations on them to suppress prostitution. What made this particular sting operation national news was that Robert Kraft, the owner of the New England Patriots, was one of the men caught patronizing the establishment and receiving sexual services. It's important to note that this was the only evidence against the defendants, was a video recording of them receiving these sexual services. Now, this sting operation essentially is called a honey trap for the unsuspecting people who are disposed to commit a crime, and they get caught up in that.
So the hidden video in the spot, is that legal?
It's not, is ultimately what the judge ruled in this particular case. That was the question put forth by the defense attorneys. Now, the Fourth Amendment protects us from unreasonable searches and seizures without a warrant. And a sting operation specifically does not involve any known suspect, but rather the identification of new suspects of prostitution. Now, in August, a 3-judge Court of Appeals panel found that the surveillance used in this case was extreme, not warranted by the circumstances, or any exception to the Fourth Amendment. And in particular, they found that to permit otherwise would yield unbridled discretion to the agents of law enforcement and the government, in the antithesis of constitutional liberty of people to be secure against unreasonable searches and seizures. Essentially, what the Court of Appeals said is, look, if you can't be secure in your right to privacy in a massage room, where can you be secure in your right to privacy? So the prosecutors are considering appealing this decision to the Supreme Court of Florida, but ultimately they declined to pursue this appeal any further and dismiss the charges.
I mean, they have a good point about the massage room. I mean, I don't know how many people would want to go get a massage. So essentially, Robert Kraft is not going to be punished for soliciting prostitutes twice?
Well, he's not going to be criminally punished for solicitation. However, as a member of a corporate board and a public figure, we all know the collateral consequences that he is going to face. And we've discussed those prior to today's show on this show. Now, regardless of the dismissal of the charges, that video was widely circulated and commented on both by members of the media and people involved in professional sports. NFL Commissioner Robert Goodell could yet reprimand Robert Kraft under the league's personal conduct policy through financial sanctions or other consequences. And I would say, Erica, that he must reprimand Robert Kraft for this conduct. Time and time again, you see the NFL cracking down on Black players for a variety of conduct that is honestly less significant than this. You may remember a few years ago, Adrian Peterson lost almost an entire season for domestic abuse of his son for spanking his son. Now that spanking went too far and he certainly deserved consequences, but he lost almost an entire football season over that. Now Robert Kraft is participating in the sex trade. What consequences will he have for trafficking in women?
It's going to be interesting to see, and I'm sure that you are going to update us in the near future.
Well, we'll keep an eye on that, as we have been keeping an eye on the saga that is the Louisville Metropolitan Police Department and their murder of Brianna Taylor. The story of seeking justice for Brianna is not yet over, as the grand juror whistleblower came out after our recording last week and came forward and asked the court to release the case that was presented by Kentucky Attorney General Daniel Cameron.
So what's going on in the case now?
This is an unprecedented development. A grand juror who sat and heard evidence in the Breonna Taylor investigation has retained counsel and asked the court to release the transcripts, the evidence, and the charging documents presented to the grand jury. Now, grand jury proceedings are secret in all 50 states and through the United States government and all of the territories of the United States. So it is highly unusual to have a grand juror identify themselves and ask the court to address a grievance. This is more frequently seen in jury trials where jurors come forward and address issues that come up during deliberations. This individual is incredibly brave, and they want to make sure that the truth gets out. What was presented by the juror appears to be evidence that the Attorney General, David Cameron, intentionally withheld evidence and withheld potential charges in order to cover for his police pals.
So what does the Attorney General say to this accusation?
Well, he's admitted that he only recommended charges of wanton endangerment to the grand jury. He claimed that prosecutors presented all evidence and that even though the facts showed use of force by these officers was, and he claims rather that the use of force by these officers was justified because they were fired upon. So he went into the grand jury with the intention of coming out of the grand jury with an exoneration of these two individuals, which is the exact opposite of what he should be doing in this situation. AG Cameron is admitted that he had a predetermined the issue of the use of force and believed that this shooting was justified before he ever took the case to the grand jury. This is another example of the oversized power prosecutors have in bringing and charging cases across the board, but with regards to law enforcement in particular. They think that because the grand jury proceeding is kept secret and because there's citizens who sit on the grand jury, that they can walk in there, manipulate an exoneration out of these citizens and walk out and say, look, we did everything we possibly could in this case, and then wash their hands clean of the murder.
Well, I mean, this is exactly what you hope would never happen. And it makes it seem like the law only pertains to citizens and not the police or the people in charge of the police. So what should we look for in the future in this case?
So attorneys all over Kentucky are combining energies and efforts to keep this fight alive. There's now the grand juror's attorney and the attorneys for the family of Brianna Taylor fighting to keep this case moving. Now, the grand jury transcripts have been released as of noon on October 2nd. And I want you to check back next week for our analysis of the contents of the evidence that was provided to the grand jury. What we expect to find is that the AG intentionally limited the case to protect the law enforcement officer. And when we are confronted with that as a community, the question becomes, how will we respond? I would expect that as the details of the grand jury transcripts are released to the public and as everybody finds out what actually happened, you're going to have an increase and a sustained effort to continue the protests. And there may be consequences to AG Cameron.
Well, it will be interesting. I mean, I wish I could say, I mean, it is definitely interesting, but these are incredibly sad circumstances. And I do wish we didn't have these topics to talk about so often.
Erica, it seems like it's a different issue every week in 2020. And one of those issues that has really kept us down and kicked us hard throughout this year has been the COVID-19 shutdowns. And as our communities start to slowly open up after those shutdowns, opportunities to socialize and attend events start to come back. Now, this week, Governor Mike DeWine announced that he's considering eliminating the 10 p.m. curfew for alcohol sales that went into effect July 30th of this year. Now, administrative pauses and freezes are ending as well, and that means that license violations and civil litigation are ramping up. All of this means that your license to drive could be at risk.
Are you seeing the OVI and the DUI cases increase?
Absolutely, Erica. Every week we see more and more DUI charges filed. Now remember that an OVI or a DUI doesn't have to be recent to be charged. Sometimes agencies have waited on lab reports or lab results. They've mailed charges after a stop, or they've issued a warrant for someone's arrest after issuing a traffic ticket during a stop. Also recall that OVI doesn't just mean alcohol or drugs. Impaired driving can be anything from being too tired to being under the influence of your validly prescribed medications. And while we haven't seen sobriety checkpoints on the scale that we're used to during the fall and football season, expect those to come back now that football and other sports are back on television, in bars, and in stadiums.
So thanks for the reminder that it's not just about drinking. It's also about prescription meds. It's about marijuana. It's about being too tired. And certainly all those things, you should not be driving while you're doing all of those things. So are there other ways that you could lose your license, or you could have your license suspended other than the reasons we just described?
Erica, the Ohio Supreme Court's administrative stay ended on July 30th, which means that civil and administrative processes are up and running again. 12-point license suspensions, child support suspensions, and commercial driver's license suspensions are all back to being processed. It's important to note that commercial driver's license suspensions can be imposed for a variety of reasons that don't involve moving offenses. Now, this can be exceptionally difficult during a time when many Ohioans have been out of work, they've lost business contacts, they've lost contracts, they've lost money, and otherwise found their livelihood impacted by the pandemic, the closures that happened as the result of the pandemic, both through the local and national economy. Now, a license to drive is not a right under the Constitution. It is a privilege granted by the state. You must be compliant with all regulations, including the payment of reinstatement fees and your licensing fees and your registration fees on your vehicle in order to receive a valid operator's license in the state of Ohio.
Are there remedies for folks that have lost their licenses during the pandemic?
There are. So driving privileges can be obtained on a county by county basis, but all of those require certain things in order to receive your limited driving privileges. First, you need proof of employment or your work schedule. You have to have a lawfully registered vehicle. You may need an ignition interlock device if your offense was alcohol related. You need proof of valid insurance, and in almost all circumstances, there's a filing fee. Now, drivers are finding it particularly difficult to receive privileges during their license suspension because so many employers have removed work from their work location to home. Now, you must have an employment schedule on employer letterhead or some other way to verify your employment in order to receive privileges for driving for work purposes. Even if you're presently working from home, you can still apply to receive limited driving privileges for things like driving to the grocery store, to doctor's appointments, or to take your child or your stepchildren to school or daycare or their other appointments. All drivers benefit from the assistance of having an attorney fill out their application and make sure that each driver receives the maximum privileges available under the statutes. Now, some courts, and in some cases by law, there's a mandatory waiting period before you can apply for limited privileges. It's critical to not submit an application before that time period runs, because if you do, your filing fees can be just lost and you'll have to repay to refile. Now, in other circumstances, privileges are almost impossible to secure without entering into payment plans or remedial driving programs through the Bureau of Motor Vehicles. Now, while Uber, Lyft, and public transportation services are limited during the pandemic, suspended drivers are turning more and more to things like bicycles and rideshare programs to get around. This is a unique situation in a confluence of events that has made a license suspension during the pandemic an even greater hardship than it was beforehand. And all the more reason for suspended drivers to seek the aid of counsel in order to help them get back on the road legally. Please do not continue to drive on your suspended license. Back when I was a public defender, Erica, when I was a public defender, one of the most difficult types of cases that I would ever come across was the driving under suspension case, because frequently these individuals had multiple prior charges. They owed hundreds, if not thousands of dollars in reinstatement fees. And it's a black hole that will suck you down. From the cost of the reinstatement fees to the costs of SR22 high-risk insurance, to the cost of having your vehicle pulled out of impound after you've been arrested and charged with this sort of offense. It is better to spend the money on a ride share and work with an attorney to get your license reinstated and or limited privileges on your case than it is to risk driving to work. You will get pulled over and you're going to face ever increasing penalties, including jail time, for committing that offense.
So thank you so much for the reminder, Brian. It has been quite a long break, and people have been drinking at home and not getting out much at all. And so it's good to know what the protocols are, what to look out for. And of course, it's better if you don't drive under the influence or tired or whatever the situation is, where it may keep you from driving properly and maybe costing yourself or somebody else their life. So thank you so much for updating us on that, Brian.
Absolutely, Erica. And we certainly discourage anybody from driving impaired, but if you're falsely accused of that offense, we're absolutely here for you. And even if you're accurately accused of that offense, we're here to make sure that you get appropriate consequences, minimal consequences, and we set you up in a situation to make sure that that doesn't happen again in the future. Now, I appreciate the kind words that you said about me, and I appreciate you participating in this conversation with me today, Erica. And to everybody else out there, in order to become more informed about your privileges to drive, police, government accountability, no-knock warrants, and all of your constitutional and civil rights, check out tlobj.com. or find us on Facebook at facebook.com/Central Ohio Criminal Defense, and on Instagram, TikTok, and Twitter at TLOBJ. We'll be back next week with a sui generis perspective on the next big thing in civil rights and criminal injustice system news, as well as a discussion of the movement to defund the police, what that would mean practically speaking, how it applies to local police agencies, and what our opinions are on that movement. Erica, my grandfather always told me don't do anything I wouldn't do when we parted ways. And today, to all of my friends and all of you out there, I say, if you do and you get caught, call me. I'll defend your rights as I would want mine defended.